This is the first steps when inheriting a tenant-occupied property in California. Hi, I'm Ashley Rivera, a real estate agent here in San Diego County who specializes in probate real estate. My partner, Kim Ward, and I work for Probate and Trust Help. Inheriting a property in California with someone living in it presents unique challenges related to the emotional, financial, and legal scenarios. This video is going to cover some of those specific details to help guide you through the process. We want to help you to ensure that you navigate this complex process with confidence. The very first step will be for you to determine the legal status of the tenant. Do they have a lease agreement? Are they a tenant at will? Are they a family member? What is the situation regarding the agreement between the decedent and the tenant? If there is a lease agreement, you'll want to review that lease agreement and make sure you understand any of the details related to timetables. This could mean making sure that you know whether the lease is a month-to-month, a 6-month lease, a 1-year lease. All of these things could be important to the legal findings for you. Another reason you'll want to understand this lease agreement is to make sure that you're following any tenant-landlord laws in the area, because you, theoretically, are the landlord now. We always suggest that you consult with your attorney for any legal guidance that you may need in this scenario. Next, let's talk about the emotional impact of having a tenant in a home that you've inherited. A lot of times, the tenant in the home that you've inherited is someone who is a relative or a close friend. Many times, family and friends who are living in a home with someone are tenants at will, which means that there isn't a lease agreement and they usually are paying month to month. Your loved one generously offered that space to that family member, and the agreement was just a handshake agreement, which is fine, but there are steps that need to be considered with that agreement. I have a quick story for you. We have a current client whose loved one recently passed. They were very generous and allowed a close friend from their community to move into one of the bedrooms in the home. This tenant is a tenant at will. There was no official lease agreement. It was just an agreement between the decedent and this tenant. They were not paying a lot for rent, but to be kind to this person, the client really wanted to work with them for having them move out in a reasonable amount of time. What our client quickly realized is that this tenant wanted more than a reasonable amount of time to move out. We suggested a few different options for helping with this situation. One of them was a 30-day notice, and another is cash for keys, which I'll talk about in just a few minutes. Our client chose to give a 30-day notice to the tenant, who was not pleased. The reason our client chose to give a 30-day notice is because the tenant wanted a full 2 months just to prepare to move out of one room, and the cost for the estate in that scenario was significant. So our client made the decision to give a 30-day notice to the tenant. I mentioned the cost to the estate. This included things like the tenant living in one room in the property and keeping the heat at 75 degrees all winter long. Normally, that wouldn't be that big of a deal, except that the bills here in San Diego caused that to be more than what the client was paying. Theoretically, this tenant was holding the estate hostage, so giving a 30-day notice released the clients from that hold by the tenant. Moving on to the next piece. It's important for the executor or administrator, when running the estate, to communicate with all of the heirs efficiently and effectively. We always suggest to our clients that they talk to all beneficiaries about what the scenario is with the situation and communicate when it comes to personal property and the sale of the home. We always find that emotions get high when beneficiaries or heirs feel like they don't know what's going on. So communication is key. With our experience, we have found that a 2-minute phone call on a regular basis to all of the beneficiaries can prevent a 30-minute catastrophe between the executor administrator and those beneficiaries. We want to try and keep as many people in the loop so that the entire process is less stressful for all of you. Another piece to this is assessing the financial impact to the estate when you have a tenant. The home may have a mortgage, and each month that mortgage is going to need to be paid. If you don't pay the mortgage, then you will go into default, and that's a whole other mess that you probably don't want to have to deal with if you can avoid it. You also want to consider the regular maintenance to the home. This could be lawn care, repairs that might need handled. These are all things that will come up whether you have a tenant or not. But with a tenant, you need to keep in mind that you still need to follow tenant-landlord laws, and that includes maintaining your end of the agreement, the lease agreement, that is. Once the tenant has moved out, you'll need to consider the insurance policy that you have on the property. We always suggest to our clients that they look into vacant home insurance. This is more expensive than traditional homeowners insurance. However, it covers you if something were to happen in a home that's empty. As the executor or administrator, you're going to be responsible for many things associated with the estate. And one of those is deciding with the beneficiaries whether you're going to keep, sell, or rent the home. If you choose to rent the home, you will either have to manage the property maintenance and all of the details regarding the rent yourself, or you will hire that out to a management company. This is another fee you're going to have to consider. If you choose to sell the property, you're going to want to consider the property valuation process. With a probate property, there's a specific type of appraisal that will take place. The probate appraisal will be conducted by a probate referee and will cost the estate 0.01% of the total value of the home. This is not an appraisal that you can avoid. It will need to be done, and it will be part of the probate process. Let's say that you have a tenant-occupied property and you would like to negotiate with those tenants to move out. One of the ways that we discussed earlier is cash for keys. This will cost a little bit of money to the estate, but in the end, it could save a significant amount of money as well. We will actually talk about cash for keys in another video. So if you'd like to see that one, please click the link and learn more about cash for keys and how that works with an estate. The final piece is for you to consult with a tax professional to understand your responsibilities related to the taxes of the estate. Many of our clients have shared that they did not know that there is actually a reassessment of the property taxes upon death of the decedent. For many of our clients, this is a significant amount of money, thousands of dollars. So it's important that you understand this particular piece of the reassessment and how it affects the financial means of the estate. We've covered some of the key aspects of inheriting a tenant-occupied property here in San Diego. We hope that you found this of value. Please like, subscribe, comment, and hit the bell button so that you are notified of all of our future videos.